October 14th, 2025, I was standing in a New Jersey family courtroom, representing myself, walking a judge through a binder of color-coded evidence that proved my ex-husband and his mother had fabricated $680,000 in fake loan documents to destroy my divorce settlement. Notary stamps dated 2017 and 2018, from a notary who wasn't even commissioned until April of 2019. Gift money quietly reclassified as loans in his mother's personal bookkeeping. Every dollar of that debt structure had been manufactured in the months before he filed for divorce, while I was rationing groceries in a studio apartment, while my daughter was sleeping in a room where I could hear the neighbors through the wall. When I looked across that courtroom at Derek, the man who had told me that showing up wasn't enough, he didn't look confident anymore. He looked smaller than I remembered. Just a man watching his choices arrive one by one and finding no place to put them. But let me start from the beginning. Before I get into the full story, if you are into stories like this, hit like and subscribe. We drop new ones every single day. I was a dental hygienist. I married a man named Derek, who worked in commercial real estate development. His family had money, not flashy money, but the kind where everyone speaks carefully and disagreements happen through attorneys instead of arguments. His mother, Patricia, managed the family's finances. She handled the down payment when we bought our house in Ridgewood, New Jersey. At the time, she wrote us a check for $340,000 and called it a wedding gift. Remember that detail. It matters later. We had a daughter, Lily, in 2019. I left my job to stay home with her because Derek insisted. He said he made enough for both of us, and he did. Over $200,000 a year, plus bonuses, joint accounts, 2 cars. I thought we were a team. Then in March of 2022, I found texts on his iPad. He'd been seeing a woman from his office for almost a year. The messages were detailed enough that I had to set the iPad down and press my hands flat on the kitchen counter until I stopped shaking. Lily was doing one of those wooden puzzles on the living room floor, maybe 10 feet away. When I confronted him that night, he didn't apologize. He didn't deny it. He said, "I held up my end, Nora. I made the money. I gave you the house, the car, the life, and you just settled into it. Like you thought showing up was enough. Like I was some kind of bad investment." I told him I wanted a divorce. And that's when I learned that wanting justice and getting justice are 2 completely different things. Derek's family hired an attorney named Martin Aldrich, 31 years of family law. Website said so. My attorney was a woman named Susan Park. She was not incompetent. That's important for me to say, because I spent 2 years blaming her before I understood what had actually happened. Susan did her job. The problem was that Derek's side had built something she had no reason to look for and no resources to find. During discovery, Derek submitted his financial disclosures and attached 6 promissory notes totaling $680,000. They showed that the money his mother had given us over the years, the down payment on the house, the kitchen renovation, a car, had not been gifts at all but personal loans from Patricia, due in full upon dissolution of the marriage. The notes were dated between 2017 and 2020. They had signatures. They had notarization stamps. They looked legitimate, and they meant that instead of splitting a marital estate worth over $1 million, the estate was effectively drained by debt before I got anywhere near it. Susan flagged the total as unusually high. She requested copies of the notes and reviewed them, but she didn't have the resources or the expertise to do what I would later learn needed to happen, which was a forensic examination of the documents themselves. Challenging fabricated evidence requires specialized knowledge and funding that most family law attorneys in standard divorce proceedings simply do not have access to. That's not an excuse for Susan. It's an indictment of a system that makes it easy to cheat and expensive to prove it. The settlement gave Derek the house, since the supposed debt against it made my equity share negligible. It gave him primary custody of Lily, because the judge found I didn't have stable housing or sufficient income. I walked away with my car and $41,000 and some change. I moved into a studio apartment in Hackensack, where the radiator clanked so loud it woke Lily up on my weekends. I learned how to make 6 different meals out of rice and whatever protein was cheapest at shop right that week. a lot of chicken thighs. But the worst part, the part that actually broke something inside me, was dropping Lily off at what used to be our house every Sunday night and watching her stand at the storm door waving with both hands as I backed out of the driveway. That's what broke me, but I need to be honest about what came next, because it wasn't some clean turning point. It was slow and it was ugly. A woman I'd gotten friendly with, another single mom from Lily's school, mentioned over coffee one morning that she had a cousin who'd had a divorce settlement reopened after discovering fabricated debts. She said, something about those loan documents never made sense to me. Your mother-in-law called that money a gift at the closing. I was there when the realtor mentioned it. I brushed her off. For weeks, I was too exhausted and too beaten down to believe the system that had already processed me would give me another chance. But one night, I think it was February, because it was freezing in that apartment and the heat had gone out again, I couldn't sleep. And instead of scrolling or staring at the ceiling, I started reading. Not message boards or comment sections, actual case law, precedents in New Jersey family court involving fraudulent debt instruments in equitable distribution proceedings. I read about forensic document examination, notary verification standards, and the legal threshold required to reopen a final judgment on the basis of fraud. And something shifted, not a lightning bolt, more like realizing there was a door I'd been walking past every day without seeing it. I didn't lose because the system was rigged against me. I lost because nobody on my side, not Susan, not me, nobody, had the training to see what was right in front of us. So I decided to get the training. I drove to Rutgers Law in Newark the next morning. It was raining, I remember that. Sat in the parking lot for 20 minutes, convincing myself this wasn't completely insane. Then I walked in and asked for an admissions packet. The woman at the front desk looked at me, wrinkled hoodie, bags under my eyes, clearly older than every student walking past, and she smiled and said, "Good for you." I took the LSAT in October. My score was not great, like really not great. Not top 20 material, or even top 50 material, but it was enough for Rutgers, and Rutgers was 15 minutes from Lily's school, and at that point in my life, that was all that mattered. The first time I sat in a law school classroom, I was 34 years old, and I was the only person in that room who had packed a second grader's lunch that morning, goldfish crackers, a ham sandwich with the crusts cut off, one of those Capri Suns. The professor asked us to introduce ourselves and say why we chose law. 22-year-olds talked about justice and public service and making partner by 30. When it got to me, I said, my ex-husband's attorney used fabricated debt documents to take everything I had, and I'm here to learn how to prove it. Nobody said anything for a second. That was January 2023. Law school at 34 is not what they show in the movies. There's no montage. There's no scene where the music swells, and you suddenly understand constitutional law. There is just reading, endless reading, casebooks that weigh 4 pounds each. I worked 3 days a week as a dental hygienist, went to classes the other days, and studied every single night after Lily went to bed on my weekends. I lived on student loans, cold coffee, and something I can only describe as controlled stubbornness. Rage is too clean a word for it. This was more like a refusal to accept that the story was over. My first semester, I nearly failed civil procedure. I got a C- on the midterm. A C-. I sat in my car in the parking garage afterward, seriously considering whether I should quit. I called my mom. It was probably 11 at night, which, looking back, sorry mom, and told her I couldn't do this, that I was too old, that I was kidding myself, that real lawyers start at 22, not 34 with a kid and a grudge. She listened to all of it. Then she said, you can quit tomorrow, but not today. So I didn't quit that day, or the next one. I retook the prep from scratch, basically lived in the library for 3 weeks straight, and pulled my grade up to a B+ by the end of the semester. Second year, I took a course in evidence and document authentication. The professor was walking us through standards for challenging the authenticity of business records, chain of custody, metadata analysis, the rules governing notarization and attestation. He put a sample promissory note up on the projector and asked us to identify potential defects. I stared at that document, and something connected in my brain so hard, I actually grabbed the edge of my desk. The format, the language, the attestation clause. It looked almost identical to the notes Derek's mother had produced during my divorce. And suddenly, I knew exactly what to look for. I spent the next 3 months requesting public records. I pulled notarization logs, threw a records request to the New Jersey Secretary of State. I cross-referenced the notary commission dates against the dates on Derek's promissory notes. And I found it. 2 of the 6 notes were dated 2017 and 2018. The notary whose stamp appeared on those notes, a woman named Helen Garza who worked in Patricia's accountant's office, was not commissioned as a notary public in the state of New Jersey until April of 2019. The stamps were real. The dates were lies. Those notes had been created after Derek decided to leave me, and backdated to look like original loan agreements from years earlier. I didn't tell anyone what I'd found. Not yet. I needed to finish school first. I needed to pass the bar. I needed to do this right, because if I came at this half-prepared, I would not get a second chance. But 3rd year, something happened that nearly ended everything. 2 months before graduation, I received a letter from the New Jersey Committee on Character and Fitness. Someone had filed a complaint questioning my fitness to practice law. The letter said the committee had received information suggesting I had enrolled in law school solely to pursue personal litigation, and that my motivations raised concerns about whether I would uphold the ethical obligations of the profession. It did not say who filed the complaint. It didn't have to. I knew. I had to appear before a 3-person panel in Trenton. I sat across from them in a blazer I borrowed from my friend Dana, hands folded on the table so they wouldn't see them shaking. They asked me to explain my reasons for pursuing a law degree. They asked if I intended to represent myself in any pending or future litigation. They asked whether I could separate my personal history from my professional obligations to future clients. I answered every question honestly. I told them the truth, that I had started law school because of my divorce, but that what I had found in the law was bigger than any single case. I told them about the clinic work I'd been doing, the pro bono hours, the families I had already helped. One of the panelists, an older woman with reading glasses pushed up on her head, looked at me for a long moment and said, "A lot of good lawyers come to the law through personal injustice. MS Callahan. That's not a disqualification. That's a calling." The committee cleared me 6 weeks later, but those 6 weeks were worse than any exam I ever took. The idea that Derek could reach into my new life and threaten the thing I had built nearly broke me in a way the divorce itself hadn't. I graduated in May of 2025, took the bar exam in July. The wait for results was the longest 6 weeks of my life. I couldn't eat. I couldn't focus. I basically just existed. Couldn't plan anything. Couldn't think past the next hour. Just waiting. When the email finally came, I was sitting in my car in a Wawa parking lot. I opened it and saw the word pass, and I sat there shaking, completely alone for 10 minutes. Then I called my mom, and neither of us could form words. We just cried. I filed a motion to reopen the divorce settlement on September 4th, 2025. I represented myself. Pro se, they call it. When the filing hit the court system, Derek's attorney must have seen my name listed as counsel for the petitioner and assumed it was a clerical error. He called me within 48 hours. Very polite, almost amused. He said, "Mrs. Callahan, I'm not quite sure what you're hoping to accomplish here." I said, "I guess we'll find out." 3 days later, Derek called me directly, not through his attorney. He said he'd been thinking, and he wanted to offer to increase his child support payments voluntarily. He said he wanted to set up an education fund for Lily. He said he didn't want her to see us in a courtroom again. His voice sounded different than I remembered. Quieter, almost tired. For about 30 seconds, I genuinely considered it. Not because the offer was fair, it wasn't even close, but because he sounded like the person I had married, and God, that's a cruel thing to do to someone, showing you the version of themselves you married, but only when they want something. I told him I would see him in court, but here's the part. Nobody tells you about trying to fight the system from the inside. It fights back. My initial motion was nearly thrown out. The judge assigned to the case questioned whether I had met the legal threshold for reopening a final settlement. Derek's attorneys filed an immediate motion to dismiss, arguing the original proceedings were conducted fairly and that I was relitigating simply because I was unhappy with the outcome. not because there was genuinely new evidence of fraud. I had 72 hours to file an opposition brief. I wrote the whole thing in one sitting at my kitchen table. Lily was asleep in the next room. I think I went through an entire pot of coffee. I cited 14 cases. I attached the notary commission records, showing the impossible dates. I attached a timeline, demonstrating that the promissory notes could not have been executed when they claimed to have been. And I argued that the original financial disclosures were not merely incomplete, but fraudulent. There is a legal difference between those two words, and I had spent 3 years learning exactly what it was. The judge denied the motion to dismiss. Discovery was reopened, and that is when the full picture came into focus. A court-appointed forensic document examiner confirmed what I had found. The 2 earliest promissory notes had been created no earlier than late 2021, based on the notary commission records, paper stock analysis, and metadata from digital templates stored on Patricia's accountant's computer, which was subpoenaed during discovery. But there was more. The remaining 4 notes, the ones dated 2019 and 2020, had been signed by Derek and Patricia, but were never accompanied by any actual transfer of funds in the amounts claimed. Patricia's own bank records showed the original transfers matching the house down payment and renovations, but they had been coded as gifts in her personal bookkeeping until October of 2021, when they were quietly reclassified as loans. Every dollar of the $680,000 debt structure that had gutted my settlement had been manufactured in the months before Derek filed for divorce, while I was rationing groceries in a studio apartment in Hackensack, while my daughter was sleeping in a room where I could hear the neighbors through the wall. And that brings us to the moment I told you about at the start. The hearing on October 14th, 2025. I walked the judge through everything I had. Every document, every record, every timestamp, organized in a binder with color-coded tabs. Not because I am naturally an organized person. I'm really not. But because I wanted there to be absolutely no room for interpretation or excuse. I need to tell you what that moment actually felt like, because I had imagined it for over 3 years, and the reality was nothing like what I expected. I thought I would feel triumph, vindication, some kind of blazing, righteous satisfaction. What I actually felt was exhaustion. I looked at this man I had been married to, the father of my daughter, and I just felt tired. Tired of fighting him. Tired of proving that I deserved what was already mine. Tired of the fact that any of this had been necessary at all. I had been fighting a version of Derek that maybe didn't fully exist anymore. And the version sitting at that table was just a man who had done terrible things and was beginning to understand that they were not going away. His attorney argued the loan reclassification was a legitimate accounting correction, and that the notary dating discrepancy was an administrative error. The judge wasn't buying it, not when every single supposed error pointed in exactly the same direction. The judge vacated the original settlement. I was awarded the house, retroactive child support dating back to the original decree, a majority share of all marital assets, as they should have been calculated without the fabricated debts, and primary custody of Lily. The judge also referred the matter to the county prosecutor's office for review, because Derek and Patricia had both signed financial disclosure affidavits under oath, swearing that all debts listed were legitimate and pre-existing obligations. When you present fabricated documents in a sworn proceeding and put your signature on an affidavit attesting to their authenticity, that is not a bookkeeping error. That is fraud on the court. And 2 weeks ago, I received confirmation from the district attorney's office that charges have been filed against both of them. So here's where everyone is now. Derek is renting an apartment in Montclair. He has supervised visitation every other Saturday. His attorney, Martin Aldrich, is under review by the State Ethics Board over questions about what he knew, and when he knew it regarding the fabricated notes. Patricia has retained her own counsel. That is all I know about her situation, and it is all I need to know. The woman Derek was seeing. They ended things in 2024. I spent a long time wanting to know the details. Then one day I noticed I genuinely didn't care anymore. And the weird thing is I can't even tell you when that happened. It must have been gradual, because I never noticed. Maybe that's the only way it works. As for me, I passed the bar. But I haven't decided yet whether I'm going to practice full-time. Right now, I'm working with a family law clinic in Newark that helps women who cannot afford forensic document examiners or accountants. Women who are sitting where I sat, being told to accept settlements built on numbers they have no way to verify, being outmaneuvered by the sheer cost of proving what they already know to be true. I tell every single one of them the same thing. The system is not designed to crush you, but it is not designed to save you either. It is designed to process you. And if you want a different outcome, you have to become someone who can read what's on the page and see what isn't. The night we moved back into the house, I carried Lily's suitcase up to her room. Her name was still on the door in those little wooden letters from when she was a baby. I set her bag down and braced myself. 3 years of building to this moment. You know what she actually did? She walked right past me, pulled her favorite stuffed animal off the shelf where it had been sitting since she left, flopped onto her bed, and said, "Mom, can I watch something before dinner?" I stood in the hallway and cried so hard I had to press my hand over my mouth so she wouldn't hear. I spent 3 years and, honestly, I don't even want to say how much in student loans to get here. Some people would call that obsessive. Yeah, maybe. But I learned something in those 3 years that I couldn't have learned any other way. And it isn't about Derek. And it isn't about revenge. Because this stopped being about revenge somewhere around the day that character and fitness panel cleared me to practice law. What I learned is that the distance between the life someone else decides you deserve and the life you actually deserve is exactly as wide as the things you are willing to learn. That's it. That's the whole thing. So what is the thing you've been told you don't get to have? And what would it take to learn how to get it?